says that she had a $5 million divorce settlement with a rock legend, but now Garcia's third wife and widow says Carolyn Adams shouldn't be permitted to take that amount of money out of Garcia's estate. Deborah Coons claims that Adams' contract with Garcia was not legal. Court TV's Clara Tuma is joining us now live outside the courthouse in San Rafael, California. Yesterday ended with lawyer David Hellman on the stand testifying about Jerry Garcia and Carolyn Adams signing this piece of paper. Some say this may have been the most significant moment so far in this case. Why?
Well, Chris, David Hellman was a longtime friend and financial advisor and lawyer to Jerry Garcia. He told the judge that he was present when this 13-line agreement was signed back in 1993. He said that Jerry and Carolyn Garcia came to his office without their divorce attorneys. He said they went into his conference room and met privately for a while. David Hellman said he came in once to see if they needed anything. They didn't, so he left. He said he came back a second time, and he said during that second visit, Carolyn Garcia got the agreement out, read it, said it seemed like a fair distribution to her, handed it to Jerry Garcia. He said Jerry Garcia appeared to read it and said it seemed fair to him. Then he said he read it and said he looked at it and said, well, boy, $5 million is a lot of money. Now, that testimony may appear to help Carolyn Garcia's claim that this was a document knowingly signed by both parties who understood just what the ramifications would be. But there may have been a plus in this testimony for the estate, and that's because the state attorney, Paul Camara, was able to show that this attorney gave a different rendition in his deposition. In his deposition, he recounted this meeting almost the same, except he said he did not recall anything that Jerry Garcia said at that meeting. Of course, on the witness stand, he said that Jerry Garcia said that document appeared to be fair.
Well, Clara, preview, if you will, for our viewers what they can expect when Court TV resumes live coverage of this case in just a few minutes.
Well, David Hellman is back on the witness stand for his fourth day of testimony, but he is expected to conclude his testimony by about noon here in California. When he concludes, the estate plans to call an accountant to the stand. Among other things, this accountant is expected to say that during the marriage, Carolyn and Jerry Garcia accumulated about $2 million. And of course, the estate says that under California law, Carolyn Garcia would have been entitled to 1/2 of that, or $1 million, not the $5 million that she is claiming.
Clara Tuma reporting live from...
You didn't have time to say, wait, let's call Stilson? Is that what you're saying?
No, overruled.
That was not my role in the meeting. I had told them, as I've testified, that I was not there acting as counsel for either of them, that they had been in communication with their counsel, and that if they were going to talk about issues and wanted to resolve issues, that was between them.
Just a minute. Now, I want to stay with the fact that there wasn't enough time. Is that what you are telling the court, that you didn't call Bruce Stilson, or you didn't notify Bruce Stilson, Jerry's lawyer, that he was committing to pay $5 million or being asked to until after he signed because you didn't have time?
No, at that point in time, Jerry did not ask me to do that. There was not time then. That was not something I was asked.
Beg your pardon?
I didn't, physically, I could have picked up the phone and dialed the phone. That's obviously the case.
That's what I want to know.
What I said was that there wasn't time because Jerry didn't ask me to do it at that time.
So you're not calling Stilson wasn't because you had insufficient time. It was because Jerry didn't ask you to. Is that your testimony?
Yes.
Why did you call Barbara Rohan?
Same reason.
Same reason.
My understanding was the parties had been in communication with their counsel.
Your understanding was what?
That they had been in communication with their counsel.
They had been in communication with their counsel.
Right.
You mean that their counsel knew that Bruce Stilson knew that Jerry Garcia was coming there to receive a demand for a settlement proposal? Is that your testimony?
No. I said Jerry had been in contact with Bruce Stilson and Carolyn had been in contact with Barbara Rohan. I don't know what they talked about with their counsel. They didn't tell me. I don't know whether Jerry knew that Carolyn was coming with a settlement proposal or not.
Well, now, Mr. Hellman, let me have that exhibit. Let me show you H31. You have it there, don't you? Where is it?
Well, what I have isn't marked, so I'm not sure.
These are your notes of May 3rd, 1993, right? Your meeting with Jerry and Carolyn?
Yes.
And isn't the last note you made here, Carolyn to decide and to make proposal at next meeting?
Yes.
So you knew a proposal was coming on May 3rd, didn't you?
Yes, but didn't know what it was going to be and whether or not it was going to be accepted. And I did have telephone conferences with Bruce Stilson between those two dates.
But you have no specific recollection of telling Stilson that a proposal is coming from Carolyn to Jerry on May 11th.
No, I have no recollection of telling him that. I know there were several phone calls between hand. We talked about many issues.
Why
I
didn't
don't
you
remember.
tell him?
I didn't say I didn't tell him. I said I don't remember whether I did or didn't.
While there's a pause here, we'll continue our live testimony of Garcia versus Garcia. Pay his soon-to-be ex-wife, second ex-wife, Carolyn Adams Garcia, $5 million to be free and clear of their marriage. And was that validly reflected in this 13-line agreement which both of them signed? That's the issue now that must be decided by a judge as we go live into the courtroom. The attorney and advisor who was there when they signed it is on the witness stand.
I believe so. She's the one that presented the proposal.
Did you tell Jerry that at any time that if he didn't agree to this $5 million deal that it could cost him more if he went to court?
I don't recall that I told him that. That issue was brought up, I believe, in a subsequent discussion, the one that we had a few months before he died with Steve Cantrock and Bob Kligman.
Now, you started your answer by saying, I don't believe I told him that.
I don't recall ever telling him that.
Mm-hmm. Now, would it be fair to say that Jerry Garcia hated confrontation?
Objection, Your Honor. It's irrelevant.
Irrelevant. Overruled.
He didn't like confrontation, no.
And isn't it true that Jerry Garcia had a serious drug problem over the 20 years that you represented him?
Your Honor, objection until there's some foundation that on the occasion of May 11th, when this document was signed by the two parties, that there is some evidence that Jerry Garcia was suffering from some disability with respect to some issue relating to drugs.
I'm not that.
Well, no, I'm going to allow this by way of background, both on the confrontation issue and the drug problem issue. If it has any relevance, it'll have to be connected up to this date, but you can go into it.
Yes, Your Honor.
And the foundation, there's a lack of foundation for this witness.
I assume it's going to be connected up.
Mm-hmm.
Go ahead with it.
Were you aware that Jerry Garcia had a serious drug problem for most of the 20 years that you represented him?
At varying times, yes.
Well, do you recall how many times he was hospitalized because of that affliction?
Well, there were multiple causes in his hospitalization. But he was in the hospital twice.
When was that?
I'm going to object unless there is some...
Yeah, what's the connection between hospitalizations and what happened on May 11th?
Well, Your Honor, if he's hospitalized, it demonstrates the seriousness of the condition. It also disabled him from touring, which is how we made the money to make these payments.
Same. It's still a relevancy objection, and I certainly want to reserve objections to move to strike at some later time unless there is some demonstrable relevance to the May 11th, 1993
I'll overrule
event.
the objection. Keep going.
All right. When was he hospitalized?
My recollection is the first time was in '86, and I believe there was another time. I'm not sure if it was '92. I don't recall exactly.
And does August of '92 sound right?
Yes.
Now, you were aware that he had this problem from the very beginning of your representation of him, right?
Which problem? Did he use
I'm sorry,
drugs?
the drug problem.
Yes.
And did you ever see him under the influence of drugs?
No.
Well, how would you know if he were in your office under the influence of drugs?
Well, his behavior didn't appear to me to be that of anybody abnormal to other clients that are in the office. I've seen people who have been drunk. I've seen people who I have presumed have been high on drugs, and Jerry didn't evidence those characteristics when he was in my office.
Well, briefly, what physical symptoms did you observe of someone who's under the influence of drugs?
Objection, Your Honor. It's a 352 objection.
Sustained. Right.
Now, did you observe that Jerry's drug addiction caused him to lose interest in his financial and legal affairs?
Objection. Lack of foundation, Your Honor, to this witness.
During the time that, well, do you recall when it was that Jerry was having his most difficult problems with drugs? Early 80s?
I really don't recall.
Well, this is one of the oddest situations you'll ever see in a court of law. The man on the witness stand, David Hellman, is essentially being accused of wrongdoing by his own attorney, which is Paul Camara. If that sounds strange, just a note of explanation. David Hellman on the witness stand and Deborah Coons Garcia, the wife of the late Jerry Garcia, are co-executors of the estate of Jerry Garcia, and the attorney doing the questioning is the hired attorney representing the estate. So it's an odd situation that rarely occurs. There may be a whole host of conflicts of interest involved in this, and one wonders how it got to this point and why it hasn't been resolved. The answer may be that Carolyn Adams Garcia, the second wife, wants her money, $5 million, which she claims Jerry Garcia promised to pay her over the course of 20 years as full payment of what was owed to her as community property during the course of their marriage. Well, let's listen again.
Sustained my objection. This is not...
Well, I'm going to allow this. Go ahead.
Question. Was there a period of time when, during the time you were representing Jerry, that he showed absolutely no interest in his financial or legal affairs? Answer. In the earlier part of the representation, he became more concerned about it in later years. Question, are you saying in the earlier part of your representation you mean in the 70s? Answer, early 80s. Question, well, okay, so in the early 80s he evidenced a lack of interest in his business and financial affairs. Is that what you're telling me? Answer, less than in subsequent years. You were asked those questions and gave those answers.
Can you answer that?
Yes. I don't see anything in those questions or answers that deal with drug use. I think as Jerry earned more money, he became more interested in money. His earnings increased in later years, and there was more opportunity.
There's no question pending, Your Honor.
All right.
Now, it was in 1992 that he made you his general attorney, in fact?
That I signed, yes, that he gave me a power of attorney.
While there's a pause here, Richard Miller is our guest commentator in New York. He specializes in trust and estate litigation. I just identified about 2 minutes ago how the attorney for the estate is really grilling and cross-examining the executor, co-executor of the estate. I mean, this is a guy who's being really accused of wrongdoing by his own attorney. And yet it doesn't surprise me that it's come to this, because there are inherent in the business of trust and estates and wills some measure of conflict of interest.
That's right. In essence, I mean, Mr. Hellman here has been a long-standing attorney for the Garcias. It may have been only natural for Jerry to have named him as an executor as well as a trustee under his will. But there comes a time in that relationship when Mr. Hellman's going to have to decide, well, am I wearing the hat of as executor and as his fiduciary, or am I a lawyer?
Yeah. And Mr. Hellman, you could see it here. He just wanted to help his clients. That's all he was doing. The clients were frustrated with their respective divorce attorneys, and so he said, look, come to my office. If you guys want to agree on your own, that's up to you. I'll provide the setting. I'll drop in, make sure everything's going okay. I'll even look over the agreement if you like. Go ahead and reach some sort of an agreement. Now he finds himself on the hot seat, accused of some wrongdoing and conflict of interest and so forth. Maybe there ought to be a solid canon of ethics, an ethical law that says if you're going to draw up somebody's will, you cannot be the trustee and executor.
You know, that's right. And certain states are taking those sorts of measures. New York State, for example, has placed limitations on what attorney executors charge and commissions, and other states are taking those same sort of measures.
All right. Well, Mr. Hellman has just said that this wasn't a complete settlement agreement, but close.
What, at the time that he witnessed it, he perceived as some ambiguity, as distinct from the witness perusing the document at this point and opining in some way about some perception he has about some ambiguity in it.
Mr. Camara, that appears to be, those observations are correct. His opinion about whether this is a complete agreement, whether it covers support, and so forth.
That part I agree. But so far as other ambiguities in the agreement, I'd like to pursue that.
Well, not through his testimony. You could pursue that in argument, and that's ultimately issues the court's going to have to rule upon and interpreting as a matter of law the effect and the enforceability of the alleged contract.
Well, Your Honor,
not for him to express his opinion.
Your Honor, this also has to do with the fact that although this agreement provides, or this document provides, that it supersedes all other agreements, Mr. Hellman continued to be involved in payments being made to Carolyn Garcia for support to the tune of another $288,000.
Well, all right. I haven't heard that question asked.
Well, maybe I didn't get at it the right way. Mr. Hellman, what verbal or written agreements were there that you know of between the parties that this agreement provides will be superseded?
Well, the support agreement was going on at about $24,000 a month.
Right.
That was supposed to be superseded.
That was supposed to be superseded.
That was my understanding in reading it.
Right. And what about the arrearage, which was in over $150,000? Did the payment of $5 million also supersede that?
Well, I object, Your Honor, to the extent that he can testify to conversations of the participants at that occasion. It may be relevant, but
That's correct.
I'll withdraw that. In your mind, in addition to superseding the $24,000 a month, did the alleged promise to pay $5 million also supersede the obligation to pay any arrearage?
objection, what's in his mind at any particular moment
Right,
about
sustain.
this is irrelevant.
Sustained.
What other agreements were there besides the support agreement?
Well, they had made some agreements to divide property, but that apparently was to continue, but I'm not aware of any other.
I'm sorry, what?
That was apparently to continue.
Well, where does it say it was to continue?
I don't see the language there. But they'd already made the division. It was a fait accompli. These were the issues remaining.
Well, they had made agreements to divide property.
Well, and they had divided most of it at that
They had
point in
divided
time.
most of it, but not all of it.
That's correct.
Right. And were those agreements superseded?
Well, objection, it's the same objection to the extent that he witnessed conversations or participated in conversations. It's certainly relevant, but to the extent that something's in his mind and he's being asked to interpret.
Right, it's the form of the question that's objectionable.
All right. What other agreements were yet unexecuted?
There were some property division issues that had not been completely finished.
Some deeds had to be exchanged, right?
I don't recall if there were any deeds left at that point in time, but I know there were some bank accounts that had not yet been divided.
All right. What other agreements?
I can't recall any.
Well, under this agreement, would those bank accounts belong to Jerry?
Not necessarily.
Well, all other agreements were superseded by payment of $5 million, right?
Objection, argumentative.
Sustained.
What bank accounts had not been divided? The joint account?
I'm aware of that one, yes.
That had several $100,000 in it, didn't it?
Yeah, I'm not sure how much at that point in time, but it did have it. When it finally was divided, there was about $260,000, something like that.
Did you raise any question at the meeting about which agreements were contemplated by that reference?
I don't have any recollection of whether I did or didn't.
Now, as I understand it, Jerry continued to pay the $24,000 a month after signing this document. Is that right?
I believe that it did continue until approximately October, and that the communications between Bruce Stilson and Barbara Rohan were such that until the arrearage had been caught up, that the new agreement would not start.
Well, Stilson consulted you on that, didn't he?
We talked about it, yes.
Yes. And you both agreed to let him keep making these $24,000 a month payments, didn't you?
I didn't agree to it. I was told what they had agreed to.
Did you suggest that some action be taken in view of the language of the agreement?
Stilson had the agreement, and he was dealing with it. It wasn't my responsibility. We
I
talked
see.
about the economics, and that wasn't my area.
The economics were not your area.
No, I didn't say that. I
I'm
said
sorry, I
the
misunderstood
economics,
you.
the raising the money was my area, to seeing where it could come from, but the terms of between the parties was not my responsibility. He was handling that with Barbara Rohan.
Now,
We're going to take a quick break. We'll be right back.